Hello students, today we'll be talking about free speech and what that means on college campuses. Given the climate in the world today, I thought this was an important topic of conversation so that you can understand how as college students you can intersect your right to free speech with your obligation to adhere to university student conduct policies and regulations. As we know, the First Amendment guarantees all students the right to freely express their viewpoints in public forums such as college campuses. However, the university has an obligation to protect the rights of all students and therefore can set guidelines and policies regarding the exercise of that free speech. The U.S. Supreme Court in the landmark case Tinker v. Des Moines set the stage for what universities can and can't do. The case is famous for the premise that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The Tinker case established that so long as speech does not substantially or materially disrupt the functioning of the school or violate policies that have nothing to do with the speech message content, it is protected. So what does that mean for you, Scarlet Knights? The Supreme Court decision in Healy v. James established that you can exercise your right to free speech on campus, but the university can impose reasonable time, place, and manner restrictions that are content neutral to ensure your compliance with university policies. They can also require student organizations and groups seeking to be officially recognized by the university to agree in advance to conform to reasonable university policies. Does that mean you can say, write, or post anything you want anywhere on campus? No, of course not. Speech that constitutes discriminatory harassment, fighting words, actual threats, or is defamatory, obscene, or incites violence is not protected speech. Let's delve into each of these categories a little further. Discriminatory harassment is conduct directed at an individual student or group of students in a protected class that is so severe, pervasive, and objectively offensive that it creates an intimidating, offensive, and hostile environment, depriving that victim access to educational opportunities or benefits. This is measured subjectively and objectively. In other words, would a reasonable person under the same circumstances act or react in the same way? This test was laid out by the Supreme Court in a famous case called Davis v. Monroe County Board of Education. There is also no exception in the First Amendment for hate speech, so it is considered protected speech. In Texas v. Johnson, the Supreme Court held that the government may not prohibit the verbal or nonverbal expression of an idea merely because society finds the idea offensive or disagreeable. Students are therefore encouraged to speak up and report issues they encounter with hate speech to the Rutgers Bias Response Team, who will investigate the matter and determine whether the speech is allowed or not allowed under campus policies. Students, also think twice before you utter words that are directed at someone which on their face will inflict harm, have the potential to immediately incite violence or cause civil unrest, and have no value in the expression of ideas. Fighting words, as they are called, may not fall under protected speech and could result in significant consequences under the student conduct policy. In the Supreme Court case Virginia v. Black, the court defined true threats as statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence directed at a particular individual or group of individuals with the intent of placing that victim in fear of bodily harm or death. Speech that would advocate the use of force or criminal activity and is likely to result in such actions is also not protected. The Supreme Court held in Brandenburg v. Ohio, a speaker must intend to incite or produce imminent lawless action, and the speech or conduct must likely produce such action in order to be considered not protected speech. Defamation is the communication of a false statement that harms the reputation of another, is communicated to a third party by someone negligently making the false statement, or if directed at public figures, with the knowledge of its falsity or reckless disregard for its truth. The Supreme Court in Miller v. California stated that for speech to be considered obscene and not protected, it must depict or describe sexual conduct in a patently offensive way, that the average person would find the speech appeals to the prurient interest, and that the speech objectively lacks any serious literary, artistic, political, or scientific value. So students, although you have a First Amendment right to express your views on campus, I hope I was able to clarify that if you are civilly disobedient by knowingly and willfully violating campus policies or the law while exercising your right to free speech, there may be consequences, such as charges under the Code of Student Conduct or even possible arrest for your actions. As always, our office is available for any questions and concerns students may have. You can reach us at rusls.rutgers.edu. As always, I wish you a great semester, and again, we're here for any questions or concerns you may have.